issue as regards to referral of questions to the Court of Appeal and the stay of proceedings. The statutory law governing criminal procedure in Nigeria, 2 weeks. Administration of Criminal Justice Act 2015. By Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. This statutory provision was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained, this court shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those 2 classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of this court, on the 27th day of October 2025, the court made an order that the defendant should negate putting his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised to that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. This court, in the interest of justice, will not close its eyes to say the court will determine all this issue in its judgments. I proceed, I deliver my judgment. Judgment.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not forget.
Defendant,
my Lord,
consultants, can you tell
No, I'm not, please.
Raised here.
Now, for you to understand what was happening there, the last time Nnamdi Kanu was in court, which was the time he was expected to give his written address to the court. So written address is where you or your counsel, right, will address the court based on everything you've already presented, right, in a written form, so to say, right? So, and it would probably like, prove your case in this sense, like summarize the entire case and ask the court to let your client go. When Nnamdi Kanu was asking them to show him the law of which, in which they are trying him, they refused. Then he said, I can't put up a defense, because he was ready to put up his defense. He was already listed his witnesses, those he was going to call to stand, based on all these allegations, or based on all these charges, according to them. So he was asking for that, right? So they denied him the law, and he said, okay, I'm not going to put up a defense, but I am going to. Then the judge, Omotosho, said, Nnamdi Kanu should go and put everything he wanted to say, his objection, and also all of that, put it in writing. In the next court hearing, submit your written, what do you call it, submission, so to say. So on the day, the last time they were in court, so Nnamdi Kanu brought back the argument of, and he wasn't just arguing, he was actually quoting the section of Nigerian laws that says, when you accuse somebody of something, you must at least show them what part of your law you are using, so that they understand, right, what should be the punishment if they are found guilty. They are supposed to be, you are also meant to tell them that, see these charges, so if you are found guilty, it is death sentence, it's life imprisonment. You have to tell an accused, your law says that. It is your law, not him. He didn't manufacture it. So he was speaking to the judge after he took over his own case and sacked his own legal team. Sacking his legal team to represent him doesn't mean that he doesn't have, legal advisors. His legal team are still very much with him, right? So which means he's not just talking out of ignorance. No. But they deliberately ignored him. Deliberately. Because this whole thing is scripted. So what is the worst they would do? Sentence him to death? And you really think they are just going to take him and go and kill him? Okay. So he decided to submit his written submission. Omotosho rejected it. He outrightly rejected Nnamdi Kanu's written submission, which is constitutionally allowed. So Omotosho is now saying Nnamdi Kanu refused to put up a defense. He refused to submit his written submission. What the hell, man? Like, this just happened just about 2 weeks ago. It's not like it's forever. There are still very much a video evidence of this. Like, why would a judge now go on and say, I went on, I've written my judgment, and I'm writing my judgment based on this, which is a lie. That's part of what we are saying. Injustice works in such a way that even you that wants supposedly your imaginary enemy killed or something, you can still very much see the entire compromise and, double standard in all of this. In other cases, people who have been charged, they've charged Sowore for treason, they charged Sowore for terrorism, they've charged him for so many other things. But because maybe it's not a big fry for them, when it got to Nnamdi Kanu, every rule got rested, every rule. And he had to speak there like, what are you saying? You didn't allow me to actually make this submission. So why are you now like writing a judgment on that? And as some already predicted, the fact that Nnamdi Kanu sacked his lawyers and at the same time he decided not to put up a defense based on what is constitutionally allowed, then he should be sentenced just like that. But not without a fight. Yeah, I'm not Nnamdi Kanu, so I would have sat through the whole thing because to me it's just like a charade. But no, it won't. Not in that circumstance. Now watch this.
Consultants, can you tell
No, I'm not, please, let me finish. It's my case. It is my case, my Lord, let me finish. My Lord, in this very court, Emeka Itiaba SAN was here, my Lord. Emeka Itiaba SAN said, at the right time we will contradict or controvert a piece of evidence. A piece of evidence given in this very court. I need to write my final written address, my Lord. I must.
Which does.
My Lord, I'm saying it clearly. I am entitled to final written address. What is my final written address? It's in the Constitution. My final written address. My Lord, my final written address. Where is it?
Can you listen to the
I'm not, my Lord, please.
Can you listen to the court?
Please, my Lord. I need to file my final written address. It's in the Constitution.
I appeal to you to compose yourself this temple of justice.
My Lord, you are biased. You are biased. This is not law. You are biased. It's not law.
Please, I beg you to compose yourself.
My Lord, this is not law. Show me where it says you can waive my right to final written address.
I beg you to
Show me.
compose yourself.
Show me where it says you can waive my right to final written address. And I'll sit down. Show me. My Lord, you are conducting their case for them. You are the one running their case for them. Let them show me that the prosecution. Show me where it says you can waive my right to final written address. And I'll sit down.
You have the right to appeal after.
No, my Lord. This is a perversion of the cause of justice. This is not law. It is not law.
Can you excuse me?
My Lord, I cannot excuse nullity and illegality.
Can you let him
It's not possible. It is not possible, my Lord. You must show me where the Constitution says you have the right to waive my written address. You must show me.
excuse him?
Show me. Show me where it says so. Show me. Show me where it says so.
Excuse him.
Is that why you brought the cameras? Is that why you brought them today?
Please.
You didn't bring it before. You brought it today.
Please.
Show me where it says you can try me on a repeat law. Show me.
Please.
Show me where it says you can try me on a repeat law. I said, show me. Show me.
Excuse me.
Show me.
Get the microphone from him.
No, leave it. Leave it. Leave it. I said, leave it. It's a vote of law. I'm under trial. I'm under trial and I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial. I'm under trial. And I must address the court. Wait. No, listen to me. Please. The judge must listen to me. No. Wait. Wait. I'm asking a very simple question. No. Wait. Please. Look, this is Supreme Court. Wait, hold on. This is Supreme Court here. Hold on a second. Hold on. I said, hold on. This is not a court of law. It's not a court of law. What you're doing is not law. You don't know the law. Show me. I said, show me where you have the right to waive my right to final address. Show me. That's what the Constitution says. Show me. Show me. You cannot show me. You cannot show me. You cannot show me because you don't know the law. You can't show me. Wait, hold on. Don't touch me. Don't you dare touch me. People who don't know law preferring over me. Show me where it says you can waive my right. Show me the place I'm asking you. Show me. Show me. Show me. Which law says you can try me an unwritten law? Show me. You cannot show me. And you're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the final written address? Where is it? Which law gave you the right to waive my final written address? Which law gave you that right? Nonsense. You think I'm trying this with you? You try with me? You are mad. What is this one doing here? What are you 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 doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. Don't touch me. Don't push me. I'm telling you, don't touch me. I'm warning you, don't touch me. I'm warning you, don't touch me. Don't touch me. Don't touch me. I said, don't touch me. Don't. Smart people. You don't know.
You saw all of that. The last time or the one before the last court appearance, Omotosho announced that he would no longer tolerate cameras in his courtroom. He will no longer tolerate people using their phones to record in his courtroom anymore. But today, they changed that. They brought all the media. Yeah, they brought all the media houses, everybody, cameras everywhere. Because the real people behind this whole show, this drama, this show of shame, the ridiculing of your own judiciary, the mockery of your judiciary, they need to watch the same. I mean, they need to watch it on their TV in their different covens. And Omotosho seems to have delivered. Yeah, he did. That Awumolo, the prosecuting counsel for the DSS and Nigeria, right, is now asking for death sentence. He wants Omotosho to sentence Nnamdi Kanu to death. They can't jail him. They can't kill him. If you believe that they are actually going to do that to him, you are more than naive than probably you admit. But the real thing here is not prosecution. It is persecution. It is. And all of this is simply because it is an Igbo man. Fulanis are killing all of us all over the place. They have spokesperson speaking for them. Gaslighting us, telling us that we are just overreacting. They are even telling us that we are Islamophobes. Islamophobes, how do you even pronounce that? They say we are Islamophobic. Simply because people who are shouting Allahu Akbar are shooting and killing kids and women, children. But they are still getting pardoned. We are seeing them on the screen. We have people speaking for them all over the place. But mention Nnamdi Kanu, everybody will lose their shit. Now let's go listen. This is where you are going to now see a written script at play. Omotosho now reading his judgment, one after the other. Right? Let's start with this one.
Declaration of a sit at home without any constitutional power, especially the accompanied by the threat, is a terrorist act. The defendant did not present any evidence to something, unquote. The defendant in the motion on notice and comprehensive written address prayed for reliefs, including for the court to discharge him, which is a typical prayer in final written address in criminal matter. No doubt. The defendant clearly knew what he was doing by opting for final written address in form of motion/comprehensive written address in compliance with the order of this court made on the 27th day of October 2025. This will therefore be treated as the final written address of the defendant, and same have been treated and considered in the entirety. The defendant had also filed a notice of preliminary objection on the 16th day of October 2025. These two should be considered in the interest of justice, as the court having ordered that all preliminary objections will be determined in the judgments. Also, the preliminary objection filed on the 16th October 2025 is also considered thoroughly in these judgments. Another aspect of denial of fair hearing raised by the defendant is that he was misled into taking his plea in the charge. When the charge was read to be, when the charge was to be read to him, the court asked if he understood English. He responded that he did. When count 1 was read to him, he at first stated that he did not understand. The court ordered the registrar of the court to read the counts to him. He understood and took his plea. For the avoidance of doubt, I will reproduce part of the proceedings of 21st day of March 2025 when the plea of the defendant was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Registrar, after reading, do you understand count 1 I read to you? Defendant, I don't. Courts, take it again. count 1. Registrar, after it, did you understand count 1 I read to you? Defendant, I do, yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you?